Exam Prep. Today is lecture 10 of Indian Polity. Yesterday we discussed articles 25, 26, 27. Right to freedom of religion. Article 25, it basically gives all the people in this country, including aliens, a fundamental right to conscience. And once this conscience takes an outward form, then you can freely profess, practice, and propagate your religion. But this is not an absolute fundamental right. Freedom of conscience is an absolute fundamental right, but once it takes an outward form, there are reasonable restrictions that can be imposed by the state. Subject to public order, morality, and health, your right to freedom of religion can be restricted. But integral to Article 25 is reform, wherein we say that all the Hindu religious institutions or temples should be thrown open to all sections and classes of Hindus. Article 25 further talks about that although you have the right to propagate your religion, but that does not give you the fundamental right to convert others into your religion. Conversion, in order to be valid, should be voluntary. It should not be through force, it should not be through inducement, it should not be through coercion. Because if you touch the conscience of the people and then thereby they convert, this is where the state cannot interfere because freedom of conscience is absolute. And the Supreme Court has propounded a doctrine known as doctrine of essentiality or essential religious practices test, wherein if there is a religion, and in religion you will have to perform some practices, some rituals. What if these practices and rituals conflict fundamental rights, violate fundamental rights, are in contravention of fundamental rights? Then what will prevail? Particularly when we look at fundamental rights such as Article 14, Article 15, Article 21, what would prevail? The Supreme Court has said in Shurur Mutt case 1954 that if there are religious practices which are integral to a religion, which are essential to a religion, without which religion cannot exist, even if these practices violate fundamental rights, these practices continue. Because these practices are integral, essential for the existence and very continuance of that religion. But the moment there are religious practices which conflict fundamental rights and these religious practices are not essential, integral to that religion, those can be set aside, those may not continue. And we have discussed how this essential religious practices doctrine was used in various cases, whether it is the Ismail Faruqi case, whether it is the Shayara Banu case, whether it is the Shabri case. But once the Shabri verdict was given, there were a series of protests in Kerala. It was alleged that the Supreme Court is encroaching into the domain of religion. There are some temples where men are not allowed, and there are some temples where women are not allowed. What is essential, what is integral to a religion, that should be left to the members of that religion, the heads of those religious institutions. Judiciary is not competent to decide on religious matters. And then a 9-judge bench has been set up which will look into various questions related to freedom of religion as to what will prevail, Article 14 or Article 25 and 26. What is the sweep of this expression? Subject to public order, morality, and health, your freedom to religion can be restricted. Should we have a relook at this doctrine of essentiality? Also, if a public interest litigation is filed by somebody who does not subscribe to that religion or subscribe to those religious principles, should the courts be accepting public interest litigations from non-devotees? Because I told you, there were no devotees who petitioned the Supreme Court calling for the entry of women inside the sacred sanctum sanctorum of the Shabrimala temple. There were these activists who wanted equality, dignity. Whether their intention was right or wrong, genuine or motivated, we don't have to get into that. But should the courts be accepting public interest litigations from activists rather than the members of that particular religious denomination? That is what this 9-judge bench of the Supreme Court will have to decide. Then we looked at Article 26, that every religious denomination, not just any religious institution or a religious body, any religion, even the sect of that religion, even the subsect of that religion, they have the fundamental right to manage and establish religious institutions, whether for the propagation of their religion or whether for charitable purposes. They can acquire movable and immovable property. They can manage their own affairs related to religion. But even this fundamental right is not absolute, because subject to public order, morality, and health, even this fundamental right can be restricted. And then under Article 27, which lays down the secular character of Indian polity, the secular identity of India's republic, wherein we say that nobody can be forced to pay tax which will be used for the propagation and promotion of any particular religion. That is something that cannot happen. So a tax in the form of jizya cannot be imposed in independent India, in a constitutional India. That is Article 27 of the Constitution. Now let's look at the last article under this category, Article 28. Can religious instruction be imparted in educational institutions? Can you be forced to attend those religious instructions or religious worship? In an educational institutions, if there is a religious ritual, if there is a religious ceremony, should you be forced to attend that religious ceremony or a worship or a prayer meeting? Or do you have the freedom from this religious worship, from this religious meeting? For that, we have 4 different types of educational institutions. One, institutions which are wholly maintained by the state. For example, we have government colleges, universities. A government college or a university comes under the definition of the state under Article 12 of the Constitution. Since the state is secular, in these educational institutions, no religious instruction can be imparted. In a university, for example, there may be a separate department for the study of Islamic studies, the Center for Islamic Studies, the Center for Buddhist Studies. Does that mean that we are violating Article 28? No. Because who would participate in studying these subjects? Basically, normally the members of their own religious communities. There have been instances where, for example, a Muslim is also studying the Vedas and the Upanishads, where a Hindu is also studying the Quran and the Hadith, other religious structures of the Muslim community. But that is voluntary. Nobody is forcing you. But if in a government college or a university, can there be a religious function wherein you are having a puja, wherein you are having to pray a namaz, or you are having a prayer meeting every Sunday? That cannot happen in an institution which is wholly maintained by the state, and you will not be forced to attend those meetings. Sir, but there have been instances where pujas have been conducted, where religious prayers have been conducted. That's okay. Why? Because Constitution says, can you be forced to attend those religious instructions? Can you be forced to attend those religious worship meetings? No. If you're doing it voluntarily, it's okay. If you're being forced, then your Article 28 is violated. You can directly approach the court. Because these are the institutions which are wholly maintained by the state. There, if a religious instruction is done, you cannot be forced to attend those religious meetings. Then there is an institution of a different kind. Institutions recognized by the state. These are basically private educational institutions. But these private educational institutions are recognized by the state. For example, a private university is recognized by University Grants Commission, UGC. A private engineering college is recognized by All India Council for Technical Education. A private medical college may be recognized by the medical body. A private law college may be recognized by the Bar Council of India. So these are private educational institutions. Similarly, there are private educational institutions which receive aid from the state. These are aided private educational institutions. In both these institutions, which come under 2 and 3, religious instruction can be imparted but cannot be made compulsory. So then what is the difference between educational institution number 1 and educational institution number 2 and 3? Listen to me carefully. Article 28 talks about freedom as to attendance at religious instruction or religious worship in certain educational institutions. There is a religious instruction going on. For example, religion is being propagated in an educational institution, or a religious ceremony is taking place. Can you be forced to attend this religious meeting, or can you stay away from this? For that, we have 4 different types of educational institutions. First category is institutions wholly maintained by the state, which means these are private, these are government engineering colleges, medical colleges, universities. In these educational institutions which are wholly maintained by the state, since the state is secular, the institution itself cannot impart religious instruction. The institution itself cannot organize religious worship. But if it is organized by others, for example, the students or some others, nobody will be forced to attend those meetings. But the educational institution itself cannot organize it because the state is secular. But then there are educational institutions which are private educational institution, but there are some private educational institutions which are recognized by the state. There are other institutions which are recognized by the state but also receive aid from the government. These are aided private institutions. Their religious instruction can be imparted but cannot be made compulsory. Why? Because these are primarily private educational institutions which do not come under the definition of the state under Article 12. But since they have the recognition of the state which is secular, since they receive aid from the state which is secular, you cannot force your students to attend these religious meetings. But then we have a fourth kind. Institutions which are established by the religious charitable trusts themselves, whether for charity, whether for the propagation of their religion. For example, you have these convent schools. You have the madrasas. You have the Khalsa schools. Their religious instruction can be imparted and can be made compulsory as well. Why? Because these institutions are basically set up by the religious institutions themselves. Religious institutions, charitable institutions, they set up educational institutions. And one such motive for them is to propagate their religion, because that's how it is done. And their religious instruction can not only be imparted, it can be made compulsory as well. So in a convent school, you may be asked to mandatorily participate in the prayer meeting every morning. praising the holy God, the Son, and the Holy Ghost. That is completely possible. Why? Because it's a private institution established by the religious institution themselves for the propagation of their religion. And if you have enrolled your son or daughter in these educational institutions, you have to be ready that your children, even if they belong to a different religion, may be forced to participate in those religious meetings as well. That is Article 28 of the Constitution. Any questions? Sir, in case of particular religious ideology is mentioned in government published textbook, is that not violation of Article 28? Now we are seeing an India of a different kind, where now there are demands from various state governments, and some state governments have already issued orders for that, where they want that Gita to be taught in the schools, Mahabharata and the Ramayana to be taught in the schools. Is that not violation of Article 28? Strictly no. Why? Because the argument given by the government is we are incorporating these lessons not because of their religious significance, but because of their moral stories. So, in moral science, because of the morality, these stories have been included to inculcate morality amongst the students. But why pick stories of morality only from one particular religion? There maybe stories of morality from the religious texts of other religions as well. Maybe you will have to pick them as well. So, if somebody approaches the court, then the court will definitely look into this matter. Prima facie, it does appear that it's a violation of Article 28. But for that, somebody has to approach the court. What kind of institution is BHU or AMU? AMU is a minority educational institution. BHU is a central university. Can teachers of government schools conduct religious ceremony in schools? If you're asking the question, can, yes. Because let's understand and accept India is a deeply religious society. So you cannot take religion out of the heart of an individual or an institution. Can the school organize it at the school level? No. Can individual teachers who are, yes, government teachers, but at the same time they have the fundamental right under Article 25 to practice their religion? Can they do it at the individual level? Yes. Religious institution itself. So their religious instruction can be imparted, it can be made compulsory as well. Thank you, Big. It's a big comment. Okay. And others need not know what that comment is. Cultural and educational rights under Articles 29 and 30. Article 29 talks about protection of interests of minorities. But this term is not defined in the Constitution. Then who is a minority? We will discuss. But Article 29 talks about protection of interests of minorities. Article 29 says any section of citizens. That means now we come to another fundamental right which is exclusively available to the citizens. First, we discussed Article 15, Article 16, Article 19. These are the fundamental rights exclusively available to the citizens. Now we come to Article 29. Any section of citizens residing anywhere within the territory of India, if they have a distinct language, script, or culture of their own, and they want to preserve that culture, they have the fundamental right to preserve that culture. Any section of citizens residing anywhere within the territory of India, because Article 29 is applicable only for the citizens. If they have a distinct language, script, or culture of their own, they have the fundamental right to preserve that culture. And preservation of culture means they have the right to agitate as well, right to organize protests as well. So if there is a population which speaks a different language X, which is not recognized by the state is not protecting this language. The members who speak this language X, they can also agitate, they can also organize protest for the preservation of their language, because the right to conserve their language, they also have the fundamental right to agitate for the conservation and protection of their language. Article 29 tells us that Indian constitution believes in unity in diversity, and not unity in uniformity. One criticism of the RSS, as given by the opposition or by the experts or activists who criticize RSS, is that RSS believes in a concept of uniformity. That means everybody residing in this country is a Hindu. Hindu, they refer as a geographical term. Somebody who is born in this land, who resides in this land, is a Hindu. But they also believe in uniformity, that throughout the country we should all be one. At one level, you may empathize, sympathize with this argument that yes, the nation, if it is one, only then can we look at various problems that we face nationally in one way, in one prism. But there are others who say India cannot be uniform because it is full of diversity. And our constitution recognizes unity in diversity by incorporating Article 29 of the constitution. And what is this culture that is sought to be protected under Article 29? For example, there are some tribals, particularly in Nagaland, where if a boy likes a girl, what the boy does, rides a horse, kidnaps the girl, and marries her. This is what we call marriage by capture. In mainland India, in the rest of the country, this is a rape. This is kidnapping plus rape, plus violating the dignity of a woman. But this is a culture that is present in some tribal societies, and that gets protection under Article 29. What if a girl likes a boy? She packs all her belongings and then enters the house of the boy and stays there and then convinces him to marry. That is called marriage by intrusion. So you intrude into the life of the boy by setting all your belongings there and convincing this boy to marry her. In the rest of the country, this would be trespass. It won't be rape, because in India, a woman cannot be charged for raping a man, but this would be a trespass. Similarly, there are some tribes in Odisha, in Jharkhand, where before the girl marries the boy, the girl marries the grandfather. That is also a culture that is also protected under Article 29. There is a Birihor tribe where when the father-in-law passes away, the son-in-law marries the mother-in-law to give her same comfort, same support. These are kind of concepts that you will find horrible. These are the kind of concepts that people in mainland India would find something very difficult to digest and understand. But you are looking at these concepts from your own prism. But when we look at the tribal culture, in tribal culture, they have the legitimacy. So any section of citizens, because these kind of practices should also be protected, because the right to conserve your culture is your fundamental right. Any section of citizens residing anywhere within the territory of India, if they have a distinct language, script, and culture of their own, and then they want to preserve that culture as well, they have the fundamental right to preserve that culture. And no citizen shall be denied admission into an educational institution only on the grounds of religion, race, caste, language, or any of them. This is the question that you should have asked me in Article 15, but you did not. And now I will pose this question to you. Sir, in Article 15, you said the state cannot discriminate only on the grounds of religion, race, caste, sex, and place of birth. So, why are there separate educational institutions for men and women? I was taught by Sarmat sir at Byju's. Now I'm approaching the Supreme Court. Supreme Court, I want admission in a government school, in a government engineering, in a government educational institution. But this government college is meant for women, but you can't discriminate against me on the ground of sex. I want admission there. Give me admission. The court will say either you have not understood what your teacher has taught you, or your teacher is not aware of the entire constitution. You should look at Article 29. And Article 29 specifically says that only on four grounds we cannot deny admission to any individual, any citizen, on the grounds of religion, race, caste, language. But can there be discrimination on the ground of sex? Yes. Can there be discrimination on the grounds of age? Yes. Can there be discrimination on the grounds of merit? Yes. But only on the grounds of religion, race, caste, language, or any of them, you cannot be denied admission if it is an educational institution which is receiving aid from the state. That is Article 29 of the Constitution. But Article 30 specifically talks about that these minorities who are not defined in the Constitution, but these minorities, they have a right to establish, administer, and manage the educational institutions of their choice. Of their choice in the sense, they can set up an engineering college, they can set up a medical college, they can set up a law college, they can set up an agricultural college, they can set up a polytechnic college, they can set up a science college, arts college, any type of college of their choice, they have the right. But who are these minorities? Article 30 says all minorities whether based on religion or language. That means Constitution recognizes only two types of minorities: religious minorities, linguistic minorities, no other minority. Although this term minority is not defined in the Constitution, but we can trace the concept of minority under Article 30, where Article 30 says all minorities, whether based on religion or language, they shall have the right to establish, to manage, to administer an educational institution of their choice. And even this article is applicable only for the citizens of India. Listen to me carefully. We have National Commission for Minorities. And there are 6 religious minorities which are recognized. That means six religions are recognized that they are the minorities in India: Islam, Buddhism, Jainism, Christianity, Sikhism, and Parsis, which is a group. They are also recognized as the minorities. That means there are six religious minorities in India: Muslims, Christians, Sikhs, Buddhists, Jains, Parsis. These are the six religious minorities. Then what is the different fundamental right available to them? That they can establish a educational institution of their choice. But every religious institution can establish an educational institution. But a minority educational institution has got some more privileges, more protections as compared to other institutions. What are these protections? Number one, when the state has to give aid, which is a state under Article 12, when the state has to give aid for education, that means for education purposes, we have to give funds. The state shall not discriminate, that we will give funds only to non-minority institutions and not to minority institutions. The state shall not discriminate in granting aid to educational institutions on the ground that it is under the management of the minority, whether based on language or religion. That means the state will have to fund these minority educational institutions as well. But that's not the only protection. Protection is number two, reservation on the grounds of caste. And we have discussed how in educational institutions, state seats are reserved for SCs, STs, OBCs. Seats are reserved for economically weaker sections of the society. Such a reservation does not exist in minority educational institutions. And further, these minority educational institutions can reserve up to 50% of their seats for their own community. And this is what the Supreme Court has said in St. Stephen's versus University of Delhi. What is the benefit of this minority educational institution? We say all minorities, whether based on religion or language. For example, Dr. B.R. Ambedkar, when this Article 30 was being debated in the Constitution, he spoke of minorities on the grounds of language as well, saying, and he gave the example, that if there are Maharashtrians who are in Tamil Nadu, if there are some Maharashtrians who have migrated to Tamil Nadu, in Tamil Nadu, they should have the fundamental right to establish educational institution. And when they establish educational institution in Tamil Nadu, that means their primary intention is all the Maharashtrians who are in Tamil Nadu should enroll in this college, should enroll in this educational institution. And in this educational institution, we will teach them Marathi. We will teach them Marathi history. We will teach them all the basic philosophy of Maharashtra, because we want to preserve our culture, because we want to conserve our language, because we want to conserve and preserve our script. And in fact, what can happen in this Maharashtrian Institute in Tamil Nadu? Up to 50% seats will be reserved for those who are from Maharashtra. Why? Because it is set up by a minority. Because even Maharashtrians in Tamil Nadu can be a minority. Even the Tamilians in Delhi can be a minority. This is according to the vision of Dr. Ambedkar. Similarly, we have 6 minorities on the grounds of religion declared by National Commission for Minorities. Muslims, Sikhs, Buddhists, Christians, Jains, Parsis. What these religious minorities can do, they can establish an educational institution. Not just establish, they can manage it, they can administer it. And I'll tell you what is the difference. What happens because of this educational institution? That means if there is a minority educational institution and there is a religious institution which is set up by, let's say, a Hindu institution, which is a majority, which is not a minority. And here is a state. State has to give fund to minority educational institution. State is not bound to provide funds to a Hindu institution, to a educational institution which is set up by the Hindu community. In minority educational institution, there is no caste-based reservation. Why? Because caste-based reservation, one type of educational institution has been kept out of it, and that is a minority educational institution. Plus, they can reserve up to 50% of their seats for their own community. Because after all, they want to preserve their culture. Not just this. When we say they can establish an educational institution, manage and administer it, which basically means they can have their own admission criteria, on syllabus, can have its own admission criteria, can prescribe its own fee, except cannot charge capitation fee. In normal language, we call it donation. That means although if you wanted admission in a private medical college, annual fee is, let's say, 2 lakh rupees. But you don't have to pay only 2 lakh rupees. You have to upfront pay 1 crore rupees or 3 crore rupees, or in some colleges 5 crore rupees. That's a donation. That is capitation fee. After that, you will have to pay the normal fee, annual fee of 2-3 lakh rupees. That is something that these minority educational institutions cannot charge. But even then they do. Even private colleges cannot charge capitation fee, but even then they do. So that is basically violation. That is why that money you will have to pay in the form of cash, not through digital transaction, because it's basically black money. But these minority educational institutions, they can have their own admission criteria, own selection criteria, own syllabus. They can charge their own fee, except they cannot charge capitation fee. Have you heard of Lingayats? Lingayats, they are a sect under Hinduism. These people are predominantly present in Karnataka. And for a long time now, they are demanding minority status. Lingayats claim, some of the Lingayats claim, that we are not Hindus. We are separate from other Hindus. We don't cremate our bodies, our dead, we bury them. And there are lots of differences between the Lingayats and the other Hindus. And that is why they have been demanding a minority status. The principal intention, why they want a minority status, is Article 30. Because once Lingayats are declared as minorities, what are the benefit? They can set up an educational institution. They can manage it, they can administer it. 50% reservation for Lingayats. And the state will not say that we will not give you aid, we will not fund you. The state has to give you funding as well. So it is principally for this reason that there are some communities which are demanding minority status so that they can set up educational institution for the protection of their own religion, for the protection of their own language, and for the upliftment of their own community. a petition was filed in the Supreme Court. My lord, why should we look at minorities at the national level? Why not minorities at the state level? So we have said that there are six religious minorities in India: Muslims, Christians, Sikhs, Buddhists, Jains, and Parsis. And they can set up educational institution of their choice. And then there are some protections available to them under Article 30 and basis various Supreme Court judgments. But Muslims are a majority in Jammu and Kashmir. In Jammu and Kashmir, should Hindus not be treated as minorities so that they can establish educational institutions of their choice in J&K? Should Hindus not be declared as minorities in Nagaland and Meghalaya, where they are a minority? Why should Sikhs be declared as minorities in Punjab? They are a majority in Punjab. So long story short, the petition before the court was that minorities should be declared at the state level rather than the national level. So we have to look at an individual state and decide who are the minorities and who is a majority, so that minorities in that particular state can set up educational institutions of their choice. The matter is pending before the court. Let's wait and watch what the court will have to rule on this matter. But this is Article 29 and 30. Talks about protection of minorities. But who is a minority? This term has not been defined in the Constitution. Article 29 says all sections of citizens of India residing anywhere within the territory of India, if they have a distinct language, script, and culture of their own, and they want to preserve that culture, they have the fundamental right to preserve that culture. And we gave some examples. And no citizen shall be denied admission into any educational institution which is receiving aid from the state only on the grounds of religion, race, caste, language, or any of them. But Article 30 then talks about right of minorities to establish, to administer, to manage educational institutions of their choice. And who are these minorities? Whether based on language or whether based on religion. Then what is the protection available to them? They still have a right to property. Right to property, which was a fundamental right till 1978, it was repealed from the list of fundamental rights in 1978, and we will discuss either today or tomorrow why it was done. But right to property basically meant that if the state wants to acquire your property, the state has to pay you compensation. And this compensation should be just, fair, and reasonable. Because no fundamental right is absolute, except Article 17. No fundamental right is absolute. So when you say right to property is a fundamental right or was a fundamental right, that doesn't mean your property could not have been acquired by the state. State could have acquired your property, but for that the state had to pay you compensation, which should be just, fair, and reasonable. But in 1978, right to property was deleted from the list of fundamental rights. But it still remains a fundamental right for minority educational institution. So if a land, if property, if buildings of minority educational institutions, even today are acquired by the state, they have to provide them compensation which is just, fair, and reasonable. So that by acquiring that property, it should not restrict this educational institution from carrying on with its mission of imparting education for their community. That is the fundamental right to property which is still attached, which is still present, which is still applicable for minority educational institutions. Then there is Article 31 of the Constitution, and Article 31 has various parts, Part 31 A, B, C, but we will discuss all these provisions in Directive Principles of State Policy. Now we will look at Article 32 of the Constitution. Dr. Ambedkar. Dr. Ambedkar said it is this Article 32 which is fundamental of all fundamental rights. If there is a fundamental right, because fundamental rights are very important, fundamental rights are for the promotion of the growth and development of an individual. Without these fundamental rights, the growth of an individual is not possible. So if all these fundamental rights are important, but which is the most important of all these important fundamental rights? And according to Ambedkar, that is Article 32 of the Constitution. Why? Imagine a scenario that all the fundamental rights that are available under the Part 3 of the Constitution, assume all these fundamental rights are absolute. Assume they're absolute. Right to equality without any exception. Freedom of speech and expression without any exception. Freedom of religion without any exception. Every fundamental right, just assume, just imagine, these are absolute fundamental rights. Except there is no Article 32. What is Article 32 basically? A fundamental right to approach the Supreme Court when your other fundamental rights are violated. That's Article 32. So Article 32 is basically a remedy under which you can approach the Supreme Court if and when fundamental rights are violated. And in fact, this remedy itself is a fundamental right. What's the difference? Listen to me carefully. Assume that there are these fundamental rights which are present in the Constitution. And if these fundamental rights are violated, there is a remedy provided to you by the Constitution. This remedy itself is a fundamental right, saying under Article 32, you can approach the Supreme Court. And the Supreme Court is the protector of your fundamental rights. Supreme Court will issue orders, and through these orders, it will protect your fundamental rights. What if this Article 32 was not present? And all fundamental rights were absolute, without any restrictions, without any exceptions. But there is no Article 32. Then our entire chapter of fundamental right would be only paperized. What is paperized? I think it was November 8, 2016, when Honorable Prime Minister addressed the nation 8 o'clock in the morning, 8 o'clock in the evening, and said, Mitro, beginning 12 midnight, all the 500 and 1000 denomination notes would be demonetized. They will remain a worthless piece of paper. That means there is a value attached to this rupee 500 to rupees 1000. What is the value? Because the RBI says, I promise to pay the bearer the sum of 500 rupees. I promise to pay the bearer, somebody who holds this note, a sum of 1000 rupees. And the signature is that of the RBI governor. That is the value which is given to this piece of paper. Otherwise, it's a worthless piece of paper. Now, when Mr. Modi said, Mitro, demonetization. Now, these 500 and 1000 denomination notes, they are a worthless piece of paper. Gandhiji's photo is still there. But you cannot go and buy anything from this note. It's a worthless piece of paper. Similarly, if there was no Article 32, But there were these other fundamental rights under Part 3 of the Constitution: right to equality, right to freedom, right against exploitation, right to religion, cultural and educational rights. These look so beautiful on the paper, but these are worthless. Because if these are violated, there is no remedy. And the beauty is this remedy itself is a fundamental right. What's the difference? If Constitution would have said, listen to me carefully, if Constitution would have said that all these fundamental rights are available under Part 3, and if they are violated, you can approach the appropriate authority as decided by the parliament. You can approach the authority as decided by the parliament, which means parliament gets to decide how these fundamental rights are to be enforced. Parliament may say, if these fundamental rights are violated, you approach this authority, and this authority is not the judiciary, this authority is the executive. But it is the executive itself which has violated these fundamental rights. So executive, which on one hand is violating your fundamental rights and telling you if your fundamental rights are violated, approach executive itself. That means executive gets to decide whether executive has violated your fundamental rights or not. And executive would agree with the executive that both the executives are perfectly fine. It is the citizen who is at fault. The remedy itself, if your fundamental rights are violated, you can directly approach the Supreme Court under Article 32. This remedy itself is a fundamental right, and that is why Dr. Ambedkar said fundamental of all fundamental rights is Article 32 of the Constitution. And how does Supreme Court protect your fundamental rights? By issuing various writs. Various writs, and such writs are 5 in nature: habeas corpus, mandamus, prohibition, certiorari, quo warranto. Let's discuss all these writs one by one. First is habeas corpus, which basically means show me the body. Let's say, for example, I am taking a lecture right now. There's a knock at the door. The police comes, arrests me. Why? I don't know why. Now I've disappeared. But you like me. And you have a self-interest as well. If sir is gone, who will teach us polity? At least for that, we will approach the Supreme Court. My lord, our teacher, he has been arrested by the police. But when we approached the police, police said, your teacher is not with us. Said, really? Sir, yes, fundamental rights have been violated. Right to life and personal liberty of my teacher has been violated. The court will issue the writ saying, show me the body. Bring this individual before us. Even before this verdict, the police will set me free. Why? Because the police knows if somehow this person is set free and then he approaches the Supreme Court will ask the police, why did you arrest him? Did you mention the date and time of his arrest in the police memo? Did you produce him before the nearest magistrate within 24 hours of his arrest? Did you inform him of the grounds on which he was being arrested? If you have not done that, you have violated fundamental rights. Action should be taken against these police officers. That is habeas corpus. Which means if the state is arbitrarily detaining an individual, then you can approach the court. The court will issue the writ saying, show me the body of this individual, bring this individual before us so that we can ask questions to this individual. If the court is not satisfied with the answer given by the executive, the court will set this individual free. You're free to go. Your personal liberty is given back to you because I am the protector of your fundamental rights. Not just this, I've told you that fundamental rights are enforced against the state under Article 12 of the Constitution. But what Supreme Court has said this habeas corpus is so important that no matter who the violator is, if the violator is a state or if the violator is a non-state entity, you can still approach us and we will issue the writ of habeas corpus. A couple, boy and a girl, they were in love with each other. Clear? The family of the girl got to know, since it was an intercaste relationship, the family basically objected to this relationship. And now this girl is confined inside her home by the father. She is not allowed to move out. She is basically under house arrest inside her home. The boy approaches the Supreme Court. My lord, I have a fundamental right violation case. Please issue habeas corpus. Why? My partner, she has been illegally detained by a non-state entity, by her father. But her fundamental right is violated. Her right to movement is violated. Because you have the fundamental right to move freely throughout the territory of India. You have the right to life and personal liberty. You have a dignity which is attached to Article 21. The court issued habeas corpus petition saying, produce this girl before us. Now, when the notice is sent to the father, father has to produce this girl before the court. Otherwise, contempt of court will be filed against the father because you are willfully, deliberately disobeying a court order. And now this girl is produced before the judge. The judge is asking the girl, what is your age? She was 18 plus, which means she's an adult, which means she has the right to decide what she wants to do with her life, which means as an adult, she has the fundamental right to marry under Article 21 of the Constitution. The court asked the question to this girl, were you illegally detained by your father? She said, yes. Are you in a relationship with this boy? Yes. Is it a consensual relationship? Yes. Do you want to get married? Whether yes, no, that is your call. Enjoy your life. Ja, Simran, ja. This time not by the father, but by the court. Not by Amrish Puri, but by the judge. That is Article 21 of the Constitution. So Article 21, that is Article 32 of the Constitution. So Article 32 makes Supreme Court the protector of your fundamental rights. Supreme Court, by issuing various writs, various orders, various directives, they can protect your fundamental rights. For example, habeas corpus. But here is a condition. Something known as locus standi. What is locus standi? For example, somebody is complaining, sending me a mail that you don't teach current affairs in your classes. I am not satisfied with your classes. You don't cover the basics of these topics. You cover things which I am not able to understand. Okay, fair enough, fine. I'm going to ask one fundamental question to this individual, to this complainant. Are you our student? Said, no, I'm not your student. I'm not even preparing for this examination. I was just randomly watching your videos and I found that you're not teaching well. Just like that. I would reply and say, you don't have a locus standi in this matter. Because you are not connected with us. If our enrolled student would say that we have a complaint and I have a complaint, I would agree to that. I will patiently listen to that complaint and I will try to amend the way I teach. Because they have a locus standi. They are aggrieved individuals. That means somebody whose rights have been violated. If they approach me, I will have to listen. I may have violated the rights of my students by not teaching them well. But I have not violated the rights of a random third person who is not our enrolled student. I will not entertain his complaint because he is not an aggrieved individual. His rights have not been violated. Enrolled students' rights have been violated. I will have to listen. In habeas corpus, who can approach the court? Whose rights have been violated? Or someone else on behalf of this individual whose rights have been violated? Who can approach the court? Who has the locus standi to approach the court? Anyone. If only an aggrieved individual can approach the court, we say locus standi applies, which means only those who are aggrieved, if only they can approach the court, that means they have the locus standi to approach the court because they are the agreed individuals. We say locus standi applies. But if there is a particular matter where not just the agreed individual, but anyone can approach the court on your behalf, we say locus standi does not apply. How? I'll give you an example. Dr. Farooq Abdullah, he was arrested. He was arrested when the special status for Jammu and Kashmir was to be revoked. And then when this matter reached the parliament, when parliament was debating this bill, Jammu and Kashmir reorganization bill, the dilution of Article 370, some members of the parliament of Lok Sabha, for example, one member of the parliament in Lok Sabha, Supriya Sule, she said, I feel sad today because next to me, Dr. Farooq Abdullah would be present and we would talk, we would discuss a lot of things. But today, when an important matter concerning his state is being discussed in the Lok Sabha, he is not present. Mr. Amit Shah, the Honorable Home Minister, he got up and said, Dr. Farooq Abdullah is not under arrest. He is free to come. But if he is not willing to come, I cannot have a banduk on his kanpatti and force him to come. That's what the statement of the Honorable Home Minister was, which some people said was not an honorable statement to be made. But be that as it may, when Farooq Abdullah, government says he's not under arrest, Farooq Abdullah says, I am under arrest. His friend, Vaiko, a member of Rajya Sabha from Tamil Nadu, he approached the Supreme Court filing a petition of habeas corpus. And what is habeas corpus? Basically, show me the body. When this petition will be filed, the Supreme Court will ask Dr. Farooq Abdullah to be produced before the court so that we can ask Dr. Farooq Abdullah, were you arrested or were you not detained? And then basically the government would be in a fix. The government would have egg on its face, saying inside parliament you said he's not under arrest. And now inside the court you will have to say, yes, we have arrested this individual or whatever it is. And the moment this case was filed in the court, Public Safety Act was imposed on Farooq Abdullah. Public Safety Act is a preventive detention law. And you can be in jail for many number of months without any trial. So now the court was told by the government that Farooq Abdullah is under Public Safety Act, which means you're not illegally detained. You're legally detained under the preventive detention law. But my point is, who can approach the court? Farooq Abdullah cannot approach the court because he is under arrest. If we would have said only the agreed individual can approach the court, agreed individual is under arrest. Agreed individual has been kidnapped. Aggrieved individual is somewhere else. She cannot approach the court. That is why locus standi does not apply. Because he is an agreed individual. If only he would have the right to approach the court, we would say locus standi applies. But locus standi does not apply. Anybody can file a case on your behalf. And habeas corpus can be filed even if the violator of your fundamental right is a non-state entity. Because habeas corpus is very important, very sacred for the integrity, dignity, liberty of an individual. That is habeas corpus. Any questions? Preventive detention law, we have discussed that yesterday. Sir, can we go to the court and file habeas corpus when kidnap has taken place? Yes. If someone is kidnapped, then court can issue habeas corpus? Yes. Can I follow marriage by capture? If you don't belong to that tribe, that is not your culture, you will be arrested. Can PIL be used here, sir? Yes, PILs can be used. Foreigners also eligible? Yes. Okay, but there is something else as well. First is what is there mentioned in the constitution. Then, what is the reality? Ideally, the moment habeas corpus petition is filed, it should be heard immediately. Immediately means does not mean at the same instant or within a day. Immediately means as soon as possible. Because even a slight delay in hearing habeas corpus petition would mean that Supreme Court has failed in its duty to be the protector of your fundamental rights. But when we look at the data of the Supreme Court, hundreds of habeas corpus petitions are pending in the Supreme Court since 2019, and majority of them relate to Jammu and Kashmir. It is alleged that thousands of people were arrested when the state was to be reorganized. Those arrests would have been justified as well, because if these arrests would not happen, then there would be chaos, there will be violence, there will be disorder in the society. But for how long? Even the courts did not pay any heed to these habeas corpus petitions. In fact, there is an IS officer who previously resigned and then joined back, Dr. Shah Faisal. He was also arrested. He filed a habeas corpus petition, and that habeas corpus petition was pending, and ultimately, after Shah Faisal was released, he withdrew that habeas corpus petition. So, on one hand, we see what is mentioned in the Constitution. On the other hand, we see the empirical reality. What is exact application of this provision in the everyday life? But that is what habeas corpus is. But some of you may not have understood this concept of locus standi. In mandamus, it would become crystal clear what exactly is mandamus. Mandamus basically means we command. Clear? What is that we command? Let's say, for example, there is a couple. Couple may belong to two different religions, two different castes. But this couple is now under threat. Why? Because it's an intercaste relationship, it's an interreligious relationship. I will not say who is, whether the boy belongs to what religion and girl belongs to which religion. That we will not discuss, because religion is an important issue. You would say, why are you saying this girl is a Muslim and not Hindu, or why the girl is Hindu and not Muslim? Emotional issue. That's why we will go away from that. We will just understand that this couple belongs to two different religions, two different castes, for example, and now they are under threat by the parents, by the families, by the society as well, by the cops as well. What they do, this couple approaches the police. Why? Because the police is a state under Article 12, and they are basically asking the police, give us protection. The couple approached the police. There is a police inspector present inside the police. The couple is asking, give us the protection. Why? Because we have run away from our homes. It's an intercaste relationship or an interreligious relationship. Give us police protection. If you don't give us police protection, our parents, our family, our cop would kill us. The police inspector, instead of giving you protection, is looking at the girl with vulgar eyes, not giving the protection. Right to marry is a fundamental right. Right to life and personal liberty is a fundamental right. Right to move freely throughout the territory of India is a fundamental right. But their right to movement is curtailed by their family. Their right to dignity is curtailed by their family. Their right to marry is curtailed by their family. They approach the Supreme Court. My lord, protection is not given to us. Can you please issue a directive to the police and direct the police to give us protection because our fundamental rights are violated? If the court is satisfied, the court will issue this mandamus and say, we command that police give them protection till they get married, and even till that time, till there is a threat perception to their lives. But who can approach the court? Only this couple. Can I approach the court on behalf of them? No. Why? Because locus standi applies. Which basically means only the aggrieved individual can approach the court. Only those whose rights have been violated, only those whose fundamental rights have been violated, they have the right to approach the court. Someone else cannot do that on your behalf. In habeas corpus, anybody can approach the court, even if they are not agreed individuals. But in mandamus, only the agreed individual whose rights have been violated can approach the court, saying my fundamental right is violated. The court, while hearing this matter, can issue the writ of mandamus saying we command the police, the executive, the public authority because mandamus can be issued only against the public authority. If the public authority, such as the police, is failing in its duty of providing protection to this couple, this is mandamus. Mandamus cannot be issued against a private institution. Why? Because it's not a state under Article 12. For habeas corpus, Supreme Court has expanded the scope of Article 21, saying no matter who the violator is, whether state or a non-state entity, we will protect you. But when it comes to mandamus, the aggrieved individual alone can approach the court, and mandamus can be issued only against the public authority, not against the private authority. That is mandamus. And since only an agreed individual can approach the court, that is why we say locus standi applies. Clear? Very helpful. Since I keep on writing while listening to you, sometimes I just lose the track. I'm an enrolled student. So you're saying I'm an enrolled student. Basically, if your rights are violated, you become an aggrieved individual. My dear, if I keep on writing whatever I say, then it will consume a lot of time. That is why you need this habit of making running notes. Whatever I'm saying, you write it. And you can also watch the recorded lecture at any point in time. Prohibition. Prohibition and certiorari, they're mostly similar with some difference. And what is the difference? Let's discuss. Prohibition means to prohibit. Prohibit why? The Supreme Court can issue this writ of prohibition to prohibit a judicial or a quasi-judicial body What is a judicial body? High Court. What is a judicial body? District Court. What is a quasi-judicial body? Tribunal. What is a tribunal? Set up for a specific purpose. To reduce burden on judiciary. What does that mean? Any dispute you and me can have. I tell you, I will see you in court. Any dispute reaches the court, and the courts are overwhelmed with cases, and the cases keep on piling, and we have crores of cases which are pending at various levels of judiciary today. Then it was thought that there are some cases which involve some experts as well. Experts in the sense, let's say there are environmental matters. I am a judge. I am well versed in the law, in constitution, in CRPC, in IPC, CPC, world constitutions, but I may not be so aware about environmental related concerns, environmental related issues. Can we send all these environmental matters to a specific tribunal which will have members from judiciary, those who can interpret the laws, and members from experts as well, those who are experts in understanding environmental degradation, so that together they can take a decision? This decision one will be quick, because instead of going through a regular court where Sunny Deol was right, Tariq pe Tariq pe Tariq, you will get a date there and not justice. You can go to a specific body with all your environmental concerns, and decision will be taken quickly. Plus, decision will be taken by experts and members of the judiciary together. That was the logic. That's how tribunals were set up. For example, National Green Tribunal. For example, CAT. What is CAT? Central Administrative Tribunal. For example, you are a civil servant. And tomorrow, once you are a civil servant, you may have a dispute with the government. Dispute related to your salary, your increment, your promotion, your transfer. Dispute can be anything. Or maybe you have been forced to compulsorily retire. Because if you violate laws, if you commit some crimes, or if you violate the rules of the civil services, then there are various actions that can be taken against you. Some of the stricter actions are, you may be forced to compulsorily retire. You have to opt for compulsory retirement. Or you may be removed from the service. Or you may be dismissed from the service. What's the difference between removal and dismissal? If you are removed from service, you can still apply for a government job later. But if you're dismissed from the service, you are ineligible for a government job throughout your life. That means dismissal is the highest degree of punishment. Below that, there is removal. Below that, there is compulsory retirement. Below that, maybe you are reduced in your rank or in your salary or in your pay. There are so many punishments that can be imposed on you. And let's say, as a civil servant, you have been removed from your service, and this matter is now before the Central Administrative Tribunal. Because you are removed by Department of Personnel and Training, you are removed by the government. Now, instead of going to a regular court where you will get Tariq pe Tariq pe Tariq, instead of going to the court, you can go to this tribunal, Central Administrative Tribunal. But CAT will have the members from judiciary. CAT will have the members from the executive as well. Judiciary, those who understand the laws. Executive, those who understand the civil services rules. So this tribunal is a quasi-judicial body. It is neither completely judicial nor completely executive, because it has members from the judiciary, it has members from the executive as well. Just like Indian Constitution, quasi-federal, neither completely unitary nor completely federal. So this tribunal is a quasi-judicial body because it is neither completely members of judiciary who are present, nor is it completely dominated by the members of the executive, quasi judicial. Sir, why not quasi executive body? Quasi judicial because after all, it gives a judgment. Now, the matter is before the court. The matter is before the Central Administrative Tribunal, whether your removal was done rightly or wrongly. That matter is before the Central Administrative Tribunal. But Central Administrative Tribunal is hearing only the government lawyer. Only the lawyer of the government is allowed to speak. What is the matter with this civil servant? Right, he has violated these rules. Very good. Sir, I have something to say. Keep quiet. We'll come back to you. Government lawyer, please tell us what is the issue. Basically, right to free trial is violated by this court. I have the fundamental right under Article 21 for fair trial. Principles of natural justice are also violated because nobody can be sentenced without being heard. I am not being heard at all. I go to the Supreme Court. My lord, I have a case. What? Fundamental rights violation case. Really? Against whom? Sir, a judicial body or a quasi-judicial body. They're not listening to my side of the story, violating my Article 21, violating principles of natural justice. If the court is satisfied, court will issue the writ. We prohibit this quasi-judicial body from proceeding further because you have violated the fundamental rights of my client. Either we will transfer this case to ourselves or we will transfer this case to some other institution, but you cannot proceed with this case because we are prohibiting you because you have violated the fundamental rights of this petitioner. This is prohibition. The case is going on between X and the government. Can Y approach the court? My lord, X, not my X, someone X. This person's fundamental rights is being violated by the Central Administrative Tribunal. Please prohibit this cat from proceeding further. X would say, but who are you? I don't think my fundamental rights are violated. Why are you approaching the court on my behalf? That is why in prohibition also, locus standi applies. When we say locus standi applies, which means only the aggrieved individual can approach the court. Done. But this is prohibition. This writ can be issued when the matter is still pending in the quasi-judicial body or when the matter is still present pending at this tribunal or the judicial body. Because since the matter was pending, I approached the court that my fundamental rights have been violated. Court will say, don't proceed further. We are prohibiting you from proceeding further. But what if the judgment is also given by this cat? What if the cat would give the judgment saying the government has rightly removed you from the service? Instead of removing, we think that you should have been dismissed from the service. I approached the court. My lord, my fundamental rights has been violated. I approached the Supreme Court. Why? Because the cat has given the judgment now. And thereby it has violated fundamental rights because they have not listened to my side of the story. They have given this verdict ex parte without hearing the other party. This is violation of my fundamental rights. The court will say, we certify, certiorari, we certify that this judgment will not come into force because it has violated my fundamental rights of my client, my petitioner. That means the difference between prohibition and certiorari is it is basically issued by the Supreme Court against the judicial body or a quasi-judicial body. It is issued by the Supreme Court only when an aggrieved individual approaches the court. But the difference is prohibition is issued when the matter is still pending. And certiorari is issued when the matter is already decided by that body. And the Supreme Court says, we certify this judgment will not enter into force. We will either transfer this case to someone else or we will transfer this case to ourselves and decide this matter. Certiorari. Which means in habeas corpus, locus standi does not apply. That means anybody can file a case of habeas corpus, petition of habeas corpus. But in prohibition, in certiorari, in mandamus, only the aggrieved individual, those whose rights have been violated, have the right to approach the Supreme Court. And then we have quo warranto, which basically means what is your authority? For example, in Jharkhand, posts were announced, advertised by the Jharkhand Public Service Commission, inviting applications for engineers. And there they had said the minimum qualification is a diploma. Even if you're an engineer, definitely you are eligible for this job. But diploma is the minimum qualification. What if a 12th class or a 12th standard pass individual has been appointed to this post? You can approach the court and file the petition of quo warranto. What is your authority? Under what authority have you been appointed to this post? What is your authority if the occupier of a public post is not qualified to occupy that post? That means a 12th standard pass candidate was appointed to this post for which the minimum qualification was a diploma. So if you were appointed, it basically means that you are not qualified to occupy that public post. You can approach the court, Supreme Court, under quo warranto. The Supreme Court will ask, what is your authority? Under what criteria were you selected for this particular post? Since this was wrong, you are removed from the office forthwith. Immediately, you are removed from the office. But what if you are appointed to a private post? For example, let's say I am the vice president of Byju's. You can approach the court. Sir, we have a quo warranto petition. Under what authority was he appointed as the vice president of a private institution? Court will reject this petition, saying we accept quo warranto only if the occupier of a post is a public institution. That means a government institution, not private institutions. If the occupier of that post is not qualified to hold that position, to occupy that position, and if the court is convinced, then the court will order the issue of quo warranto and the occupier of that post will be removed forthwith, immediately. And in quo warranto also, principle of locus standi does not apply. Does not apply, which means principle of locus standi does not apply, which means only an aggrieved individual approaching the court? No. Anybody can approach the court. Who becomes an aggrieved individual here? For example, you are preparing very hard for the civil services examination. Getting up early in the morning, it's not an easy job, particularly if you are a late night person. I'm a morning person, so I can get up at 4 o'clock. I usually get up at 4:30, so that's not a challenge. But somebody who is preparing for this exam, getting up early in the morning, 6 o'clock, and then attending this boring lecture, it's a difficult task. But you're still preparing very hard. But imagine a situation, there is another candidate who is chilling right now. He's sleeping right now. And then he will get up, he will have breakfast, Netflix, and then he will go out, stroll in the sun, and then have lunch, will come back, will just glance through the newspaper, and finally you will see that his name is there in the final merit list, the final list released by the UPSC. Is he qualified to hold that post? Yes. Why? Because he is a graduate. 22-year-old. 21 is the minimum age required. So he is qualified. But he did not even appear in the civil services examination. Without appearing in the civil services examination, without qualifying the three stages of this examination, this person has been appointed as an IS officer. Which means Article 16, which says there shall be equality of opportunity in public employment, that is violated. Which means there is discrimination which has happened in this case. Does that mean only those who appeared in the civil services examination, they can file this quo warranto? Because you are an agreed individual, your job has been snatched by this individual? Or can anybody approach the court, even if you are not an aspirant, even if you are not a candidate, even if you are not an aspirant, anybody can approach the court, file the petition of quo warranto? That means principle of locus standi does not apply. And if the court accepts that yes, you have been wrongly appointed, you are not qualified to hold that public post, the court will order your removal forthwith, immediately. And that is how, through these five writs of mandamus, certiorari, prohibition, quo warranto, and the habeas corpus, the court becomes the protector of your fundamental rights under Article 32. And this Article 32, which is the remedy in case your fundamental rights are violated, this remedy itself is a fundamental right. Any questions? Let me know. What is the difference between prohibition and certiorari? Prohibition can be issued by the Supreme Court when the case is pending. When your case, where you are alleging violation of fundamental rights, that is still pending. But if the final judgment has also been given in that case, then the court will issue the writ of certiorari, not prohibition. Can Supreme Court issue writs to high courts? Yes. Can we approach against MLA for quo warranto? You cannot move against MLA or a minister under quo warranto because the removal can be done by the governor. So you can approach governor instead. Does locus standi apply to writ of quo warranto? No. Supreme Court can prohibit both judicial and quasi-judicial body? Yes. What happens to Article 32 during emergency? Please, sir, every time you don't take my questions. Now I have. Emergency we have not discussed. Clear? But if you want an answer now, Article 32 is used when your fundamental rights are violated. You can approach the court under Article 32. But there are some fundamental rights which during emergency are suspended. Or should we say the enforcement of these fundamental rights are suspended. Except Article 20 and 21. So if 20 and 21 is violated even during emergency, you can approach the court under Article 32. But let's say your freedom of speech and expression is violated. You cannot approach the court under Article 32 during emergency because during emergency, Article 19's enforcement is suspended. That's the difference. Sir, will you discuss Keshavaranda Bharti case? I will, but not today, tomorrow. Prohibition applies only on judicial bodies? Yes. Abhijit, I'm seeing your question, but what is the question? Can Supreme Court itself violate fundamental right of any citizen? That is why we discussed in Article 12, does judiciary come under the definition of the state? No. Why? Because it is inconceivable to even think that a body which is responsible for protecting your fundamental rights is itself capable of violating your fundamental rights. Can PIL be used in quo warranto? Yes. But we have not discussed PIL yet, so I cannot tell you the details of it. Wait, have patience. I think November 7 is when we have the last class. We may have to prepone that. Maybe we will not take the last class on November 7 because I've got some work, but we may take an extra class on a Saturday or a Sunday, so that on 6th itself we can complete the classes. But in 25 classes, we will cover the complete syllabus. At that time, if you have these doubts, then you can let me know. Sir, I think my question is not visible to you. Your guess is as good as mine. Power of Parliament to modify the rights under Article 33 of the Constitution. If citizens have the fundamental right to freedom of speech and expression, you can say whatever you want to say, you can express whatever you want to express. There was one Jawan from the BSF, Border Security Force. He complained against the lack of quality food. He was dismissed from the service. Later on, he tried to contest elections against Mr. Modi. Even his nomination was rejected. Why are we treating members of the defense forces separately? Why can't they have freedom of speech and expression? Or if you have the freedom to form unions, associations, and cooperative societies as a fundamental right, we have various student organizations, for example, National Students Union of India, which is affiliated with the Congress Party, Akhil Bharati Vidyarthi Parishad, ABVP, which is affiliated with the BJP, and we have the student wing for Samajwadi Party, for Aam Aadmi Party, for Trinamool Congress, for various other political parties. But why don't we have a union in armed forces, in army for that matter? Various unions, one union supporting the BJP, other union supporting the Congress. Why? If right to religion is a fundamental right, why are there restrictions on the practice of religion when it comes to the members of the armed forces? It is possible because of Article 33. Article 33 says Parliament has the power. What Parliament you can do? You can modify the rights which are mentioned under Part 3 of the Constitution. Modify for whom? Modify for those who are the members of the armed forces. Modify for those who are the members of the forces charged with the maintenance of law and order, which means the police, which means the paramilitary troops. Members of those who work in intelligence and counterintelligence organizations. Members of those who work in telecommunication system in these institutions. Freedom of speech and expression. Right to life. For example, if there is a spy sent on a mission and the mission fails, the government can disown that spy, saying we will not ensure your right to life. Is it possible? Yes, because of Article 33. There are people who are working in the telecommunication wing of army, of raw research and analysis wing, intelligence bureau. These people, their fundamental rights are restricted. They don't have freedom of speech and expression. They don't have the right to form unions, associations, and cooperative societies. They may not have right to religion as well, right to practice their religion as well. So their freedom, their fundamental rights can be modified. By whom? By the Parliament. Because Parliament has the power to modify the rights under Part 3 of the Constitution. But not for everybody, but for those who are the members of the armed forces, those who are members of the police and paramilitary, those who are working in intelligence and counterintelligence organizations, those who are working in the telecommunication wing in these institutions, in army, in police, in paramilitary troops, in counterintelligence and intelligence organizations. That is Article 33. And Article 34 talks about something known as the martial law. And what is this martial law? Not defined in the Constitution. What is martial law? Never imposed in India. But what is martial law basically? It says restrictions on rights conferred by this part while martial law is in force in any area, which means martial law can be imposed either in the entire country or any state or any part of that state. But what is mentioned in Article 34? Notwithstanding anything in the foregoing provisions of this part. That means forget about right to equality, right to freedom, right to religion, forget about those. Parliament may by law indemnify any person in the service of the union or state or any other person in respect of any act done by him in connection with the maintenance or restoration of order in any area within the territory when martial law is in force. What is Article 34 basically? It talks about what will happen during martial law, or to be more specific, what will happen to those who are responsible for ensuring law and order during martial law. And what is martial law? If the situation of this country turns so bad, where the political class is unable to handle this, where the police and the paramilitary troops are unable to handle this, then what will happen? The government may impose martial law. That means army will be called in, and army will be responsible for maintaining law and order in the society, because army is the last resort. Why? Because if there are protests, violent protests, first police has to respond to those protests, because the law and order is under police. Police, they may use lathi charge, but even then the protests continue, violent protests, they destroy property, they're killing people. If not lathi charge, if that is not fruitful, effective, then the police will start using water cannons, will start using rubber bullets. Nothing is happening. Then the police will start firing in the air to disperse the crowd. Nothing is happening. Then the police will shoot, but they will shoot the legs so that these people don't die. They injure and then they can disappear. Even if that is not happening, that is not working, then the last resort is shoot to kill. That means this policeman is trained to do a lot of things. Is trained to do a lathi charge, is trained to fire a rubber bullet, a water cannon, fire to injure, fire to kill is the last resort. But even if the situation is so bad that even then the police, the paramilitary troops, they are unable to control the situation. What will government do? Government will say, call the army. But army would need protection. What sort of protection? Army would tell the government, see, we don't know how to do a lathi charge because we are not trained in that. We don't know how to use water cannons, rubber bullets. We are not trained with that. We are trained with only one thing. What is that? Shoot to kill. So we will kill people, but we will ensure that whatever mandate you have given us, we will ensure that. We will ensure law and order is restored in our country or any part of our area. The government will say, don't worry, we will protect you. Said, how? What sort of protection do you need? Protection in the sense, through this process, we may also kill innocent. We don't know. We may also kill innocent, but if your final objective is law and order, you have to be prepared for the collateral damage as well. We may end up killing innocents as well. That is our mandate. But law and order will be restored. The government will say, don't worry, we will ask the parliament to pass a law to indemnify these people, to basically protect these people, to provide them immunity. No matter what you do during martial law, no action can be taken against you. No matter what you do during martial law, no complaint can be filed against you. No matter what you do during martial law, you will not be held answerable in any court of law, because your primary purpose is to ensure law and order when martial law is enforced within the country. That is Article 34 of the Constitution. Sir, is it similar to AFSPA, Armed Forces Special Powers Act? The impact of martial law would be similar, because Armed Forces Special Powers Act, which is there in Jammu and Kashmir, which is there in Manipur, which is there in some districts in Assam, and they want to repeal it. Under Armed Forces Special Powers Act, One area is declared as disturbed. So if this is Jammu and Kashmir, or if this is any part of the territory of India, the first prerequisite for applying AFSPA is that area should be first declared disturbed. That means it's a disturbed area, which means the police, in a sense, cannot handle this, which means there is a lot of terrorism or terrorist activities, unlawful activities going on. And to make this disturbed area undisturbed, to prevent the disturbance, we need AFSPA, which means the army, the police can shoot to kill. Normally, what happens if I have to search a particular house, if I'm part of the police or the army, I have to first take the permission from the magistrate, from the judiciary, that I need to search this house. Without this magistrate's warrant, I cannot search that house. That's why you would have seen in the movies the police enters a house of an important politician or a bureaucrat or a top individual, said, "Where is the warrant? Without warrant, police inspector, I will not allow you enter." Whatever it is. But since under disturbed areas, their area is already disturbed, and we know that in this particular house there may be terrorists holed up. Should we first go to the judiciary, take the warrant, then show this warrant to these terrorists, and then say, "Can we please enter?" They will shoot us till then. That means in these disturbed areas, the army, the police can enter, can search a particular house even without warrant. And they may even kill on mere suspicion. I may kill somebody on suspicion if I'm part of the police. But if it is happening in normal area, I will be suspended by the government. Investigation will be ordered against me. Why did you kill somebody on mere suspicion? But in disturbed areas under AFSPA, I can kill people on mere suspicion as well. Why? Because in this area, which is a disturbed area, we have to restore order. So AFSPA being applied throughout the country would become martial law. And during martial law, all those people who are responsible for maintaining law and order, Parliament may protect them from any possible cases later on. That is Article 34. Is in a position to handle the situation. The police, the paramilitary troops, they are able to handle the situation. Not everything needs to be defined, right? Untouchability also is not defined. So there are some things that we assume that we know what the definition is. And if you still are not sure about the definition, then there is a law which talks about interpretation of the Constitution, known as the General Clauses Act. Whatever definition is mentioned in the General Clauses Act, that would be the definition of the Constitution. How martial law is different from national emergency? Because in national emergency, even the fundamental rights are restricted. In national emergency, the legislature comes under, the state legislature comes under the control of the parliament. So many other things happen in national emergency. In martial law, it is specific to maintenance and restoration of law and order, nothing else. Who will be the head of the state during martial law? Same political class continues. Prime Minister continues. President continues. Sir, is AFSPA a martial law? It is not a martial law, but some aspects of AFSPA will happen in martial law as well. Nirbhay, I am acknowledging your question, but what is your question? Can martial law be applicable in very small part of the country or always in the whole country? Restriction on rights conferred by this part when martial law is in force in any area, which means it can be any part of the state, it can be entire state, it can be entire country as well. Now, Article 35. Let's say we have these fundamental rights mentioned in the Constitution. There are some fundamental rights which apply on their own. That means, for which we do not need to pass any law. Because right to equality, it is easily enforceable. It is easily implementable. You don't have to pass a law to ensure right to equality. Because right to equality is self-executing. But there are some fundamental rights for which we need laws to implement them. For example, traffic in human beings, Prevention of Immoral Traffic Act. We need a law to enforce this. Similarly, there is a prohibition on child labor. But to enforce this, we need a law. Child Labor Abolition and Regulation Act. Untouchability is abolished. But what if some people practice untouchability? For that, we need a law known as the Atrocities Act of 1989. But who has the power to pass those laws to give effect to these fundamental rights? To give effect, to get these fundamental rights implemented, we need some laws. Who has the power to make laws? Parliament or state legislature or both? This power is given only to the parliament. That means parliament alone has the power to legislate, to make laws, to give effect to all these fundamental rights. That is why, whether it is Child Labor Abolition Act that was passed by Parliament, whether it is Atrocities Act which was passed by the Parliament, whether it is Bonded Labor Abolition Act, it was passed by the Parliament, whether it is Prevention of Immoral Traffic Act, it was passed by the Parliament. So any law to give effect to fundamental rights, that right to pass such a law is given to the Parliament, not to the state legislature. We will just discuss the difference between Article 32 and 226, then we will take a break. Okay? Under Article 32, you can approach to Supreme Court if your fundamental rights are violated. But you can also approach the High Court under Article 226 in case your fundamental rights are violated. This is what we call writ jurisdiction. What is writ jurisdiction? The Supreme Court will issue various writs such as habeas corpus, mandamus, certiorari, prohibition, quo warranto, and through these writs your fundamental rights are protected, your fundamental rights are safeguarded. Similarly, high courts can also issue these writs for the protection of your fundamental rights, for upholding your fundamental rights. So that is what we call writ jurisdiction of Supreme Court and High Court. Supreme Court can issue writs under Article 32. High courts can issue writs under Article 226, same writs for the protection of your fundamental rights. But we say this writ jurisdiction of a high court is wider than the Supreme Court. Writ, basically a directive. Why writ jurisdiction of High Court is wider than that of the Supreme Court? Because high courts can issue writs for the enforcement of fundamental rights as well as legal rights, while Supreme Court can issue only for fundamental rights. We say the writ jurisdiction of High Court is wider than that of the Supreme Court. If your fundamental right is violated, you can approach the Supreme Court. Supreme Court will issue writs and your fundamental rights will be protected. But what if your legal rights are violated? For example, your right to vote is violated. which is a constitutional right. For example, your right to information is violated, which is a statutory right. You cannot approach the Supreme Court because Supreme Court is there only for the protection of your fundamental rights. But what if your right to vote is violated? How? Your name has been deleted by Election Commission of India. You approach the High Court. My lord, please issue writ of mandamus. Why? Because this public body, Election Commission of India, has violated my legal right, my right to vote, by deleting my name from the voter list. High Court will say, we command mandamus, we issue mandamus to the Election Commission of India. Include this name, the name of this petitioner, inside the voter list. Or tell us, why have you deleted his name from the voter list? Or tell us whether he should be included or not included. We command. Or your right to information. I approach the, let's say, the government, saying, where have you spent 1 lakh crore rupees, where you are saying that you have spent this money in constructing schools, but give me the list of those schools which you have constructed after 2014. For example, the government says we will not provide you the data, or the government is delaying it, not providing this data within 30 days. I approach the Information Commission. Please give me this data, because I asked government is saying we will not give, or the government is delaying it. Information Commission is also delaying it, because information commissioners are appointed by the government. They are also delaying it. Now I approach the High Court. High Court, my right has been violated. My legal right has been violated. Which right? Right to Information Act 2005. I wanted information, but the government is not providing the information. And the State Information Commission or the Central Information Commission is also not helping me. The High Court will say, we command the Central Information Commission, give this individual that data that they want. Or we command the government, give this information, the data that you're wanting. Long story short, what is the difference between Article 32 and 226? Under Article 32, you can approach the Supreme Court if your fundamental rights are violated. But you can also approach the High Court under Article 226 if your fundamental rights are violated. So you can approach High Court as well as Supreme Court when your fundamental rights are violated. But you can approach only the High Court if your other rights are violated, other constitutional, other statutory rights are violated. But we say this power to issue writs of High Court is wider than that of the Supreme Court, because Supreme Court can issue writs only for the protection of your fundamental rights, while the High Courts can issue writ for the protection of fundamental rights as well as other legal rights, whether constitutional or statutory. Right to information is a legal or statutory right. Right to information is a statutory right, which means it's a legal right. But if this is right of information to seek the details of the candidates contesting elections, to check their educational qualification, that right is a fundamental right. Sir, but state legislatures make laws on primary education, which is a fundamental right. Education comes under concurrent list. So both state as well as parliament can make law on education. Can High Court deny to take case for enforcement of fundamental rights? Yes, High Court can deny. High Court can tell you can approach the Supreme Court directly. So does our PM's request of educational qualification is also violation of fundamental right? Yes, Mr. Kejriwal asked for these details. He was imposed with a fine. Can I approach any High Court irrespective of my resident and birth to file a case? Depends on what the case is all about, where the issue has arisen. There you can file the case. What court can do if the government does not follow court order? The chief secretary will be arrested. statutory rights are legal rights? Yes. What if we are not satisfied with High Court? Approach to Supreme Court. High Court can issue writs against private body? No. Okay, let's take a break. We will meet 8:20. See you on the other side of the break. On your religion can be imposed in the name of uniformity, so that uniform for all the kind of students should be common, and on that ground it is constitutional. But now the matter is before the court, before the Supreme Court. Let's see what the Supreme Court will say on this matter. Can we directly move to High Court for enforcement of legal rights? Yes. Okay. Now let's look at some of the constitutional bodies. What is a constitutional body? A body which is mentioned in the Constitution. Whether it was originally there or whether it was added to the Constitution through a constitutional amendment. So any body, any institution which is mentioned in the Constitution becomes a constitutional body. For example, Union Public Service Commission is a constitutional body. State Public Service Commissions, constitutional body. Election Commission of India, Finance Commission, all these are constitutional bodies. And then we have constitutional bodies such as National Commission for Scheduled Castes, National Commission for Scheduled Tribes, National Commission for Backward Classes. Originally, there was one commission, National Commission for the Scheduled Castes and National Commission for Scheduled Tribes. It was one body. But by amending the Constitution, 89th Constitutional Amendment Act, (2003), this National Commission for Scheduled Caste and Scheduled Tribes was bifurcated, was split into two. So that now we had National Commission for Scheduled Castes and National Commission for Scheduled Tribes. Then National Commission for Backward Classes initially was a statutory body. That means this body was created not by the Constitution, but by the law passed by the Parliament, a statutory body. But this statutory body was given a constitutional status by amending the Constitution, by providing Article 338 capital B, and this was done by 102nd Constitutional Amendment Act. But now the question should be on your mind, what difference does it make? Why should a constitutional body have more powers as against a statutory body? Or what difference does it make to convert a statutory body to a constitutional body? Imagine a situation that we have a statutory body, let's say National Human Rights Commission, which is tasked with looking at the human rights of the people. Whenever there are human rights violations, National Human Rights Commission will investigate those violations, will ultimately prepare a report, will submit this report to the president. But president is not bound to table this report on the floor of the parliament because it's a statutory body, it's not mentioned in the Constitution. President may or may not table this report on the floor of the parliament, which means on parliament there will be no discussion on this particular report, or the report will be tabled today and for the next 5 years this report will not be tabled. That means National Commission for Backward Classes, when it was a statutory body, it would have presented a report, prepared a report, given this report to the president, but it is not binding on the president to submit this report and table this report on the floor of the parliament, which means parliament would be kept in dark as to what are the recommendations of this commission. There will be no discussion on this report inside the parliament. But once it is created into a constitutional body, now every year this report of this body has to be presented before the parliament, which means there will be discussion in the parliament on this report. And ultimately, questions will be asked to the government. What have you basically done on this report? What is the action that you have taken on this report? How many recommendations of this commission you have accepted? How many recommendations you have rejected? Why did you reject those recommendations? There will be thorough debate, discussion inside the parliament. That's the beauty of a constitutional body. So initially we had National Commission for Scheduled Caste and Scheduled Tribes as a single body. It was bifurcated in 2003 by 89th Constitutional Amendment Act. Now National Commission for Scheduled Tribes was created as a separate body. Article 338 capital A. In 2020, 102nd Constitutional Amendment Act was passed. Now, National Commission for Backward Classes, which was previously a statutory body, was given a constitutional status by the 102nd Constitutional Amendment Act by providing Article 338 capital B into the Constitution. Powers, roles, functions, responsibilities are same for all these bodies. If you understand the details about one body, you understand the details of the two other bodies as well. Because the role, power, function is same. How? Let's look at National Commission for Scheduled Castes. Created through 89th Constitutional Amendment Act, because previously it was a single commission split into two. This National Commission for Scheduled Castes, what is the purpose? To oversee the implementation of various safeguards provided to scheduled castes under the Constitution. Untouchability is abolished, and its practice in all its forms is forbidden. There can be no discrimination on the grounds of caste. If at all there is a discrimination, if at all untouchability is practiced, this National Commission for Scheduled Castes, the purpose of this commission is to oversee all these safeguards that are mentioned for SCs in the Constitution and ultimately prepare a report. What is the composition of this body? It will have a chairman, a vice chairman, and 3 other members who are appointed by the President of India. What is the role of National Commission for Scheduled Tribes? There are various constitutional safeguards for scheduled tribes. To oversee whether those are being properly implemented or not, that will be the mandate. That will be the purpose of NCST. There are various safeguards for other backward classes. Other backward classes, they should be provided reservation in government jobs, in educational institutions. Whether those safeguards are being met or not, to oversee them, there is National Commission for Backward Classes. And the composition is, there will be a separate chairman for all the 3 bodies. There will be a separate vice chairman for all the 3 bodies. There will be 3 other members appointed by the president for all the 3 bodies. That is the composition, that is the purpose of these bodies. What is then the duty and the function of this body? To investigate and monitor all matters relating to safeguards provided by SCs, to evaluate working of such safeguards. If there is no discrimination on the ground of caste, if that's the safeguard provided by the Constitution, whether those are implemented or not, followed or not, or whether some violation has taken place, we will investigate. Who? National Commission for Scheduled Castes. Similarly, to inquire into specific complaints. If a member of the SC community has been deprived of his or her rights, who will investigate that matter? National Commission for Scheduled Castes. This commission will also participate and advise the government that these are the specific schemes that you should implement for the upliftment of SCs, for providing safeguards to SCs. These are our suggestions. Please implement them. Whose duty is this? Whose function is this? National Commission for Scheduled Castes. Similarly, to present to the President reports on the working of these safeguards. Now the report is presented that this is where violation has taken place. This is where the safeguard was not properly implemented. This is where we have received a lot of our complaints. Members of SC community, they approach the police filing an FIR, but the police is refusing to file the FIR. So even in police, atrocity is committed by the police against the members of the SC community. All this will be presented in the form of a report to the President of India. Make recommendations. How can you make the police effective institution to fight against untouchability? Police should be sensitized that you should not discriminate on the ground of caste. Police should be sensitized that no matter what, you have to file an FIR. Police should be sensitized. Can we also not have reservation in police as well? What sort of reservation? Although you are recruited and there is reservation at the time of recruitment, but should we not also ensure that periodic training is given to these police officers, sensitizing them about the caste? Should we also not ensure that if there are 30 police stations in a particular district or particular state, now half of these 30 police stations should be manned by the SHO who should belong to SC community, so that there is no discrimination against the members of the SC community? All these recommendations will be presented to the president in the form of a report. To discharge other functions in related to protection, welfare, and development of the advancement of the SCs, Parliament may give additional responsibility to this commission. President may give additional responsibility to this commission. All these are the duties and functions of the National Commission for Scheduled Castes. And similar functions are for National Commission for Scheduled Tribes as well. You just have to replace SCs with STs. You just have to replace SCs with OBCs, and the duties and functions remain the same. Similarly, what are the powers of this commission? While investigating these matters, NC has all the powers of a civil court. What is a court? In court, you ask the people to be present. There's a particular case, we will issue a directive to the police. Your senior officer should be present before the court. I will order an investigation. Let the police investigate this particular matter. That's the power of the court. Same power is given to National Commission for SCs as well, STs as well, OBCs as well. They will not have the power to punish individuals, but they will have the power to order investigation. They will have the power to inquire into various complaints. They will have the power to get the documents. For example, an SC member said, I tried to file a case before the police failed to register that case. This National Commission for Scheduled Castes will ask all those documents to be presented before this commission. Why the FIR was not filed? When this person entered the police station, because his name is mentioned in the police entry, why did you not register his FIR? All these documents you have to produce before us. That's the power of this commission. Union and every state government shall consult this commission on all major policies affecting the scheduled castes. So whether reservation should be given in promotion or not, whether specific schemes should be created for the SC community or not, for all these policy matters, central government as well as state government shall have to consult this commission. Shall. It's not may consult. It's not can consult. Shall consult this commission. Similarly, for all the OBCs, National Commission for Backward Classes would be consulted. Similarly, for all STs, National Commission for Scheduled Tribes would be consulted, shall be consulted. And it can summon any person. Any police officer can be summoned by this commission. Any bureaucrat can be summoned by this commission. A bureaucrat is not giving caste certificate to you. You are from SC community, but this caste certificate is not given to you. You approach the police, you approach the district authorities, nothing is happening. You approach the commission, and commission will summon this officer. Please come. Why have you refused to grant the caste certificate to this individual? Recovery and production of documents. How many caste certificates have you issued in the past? Give us all those details so that we can see whether you are biased against the members of the SC community. Receiving affidavit, evidence on affidavit. Did you refuse to give him caste certificate or not? Give us in the form of an affidavit, which you have to swear by, because this affidavit can tomorrow be produced before the court of law, and this will be used against you. Any public record, any copy of the court, any copy of any order of any office can be summoned, can be requested by this commission. Give that order to us. We will look into that. Summons. You approach the police for filing an FIR. You have a friend with you who is witness to all of this. The police has refused to accept and file the FIR. Summon that witness before us so that we can satisfy ourselves whether the police is right or this individual is right. All these are the powers of this commission. And similar powers are there for the National Commission for Scheduled Tribes, National Commission for Backward Classes as well. But when this 102nd Constitutional Amendment Act was passed, which gave a constitutional status to National Commission for Backward Classes. Listen to me carefully. We have a central list of SCs and STs. That means there is a central list throughout the country. These are the SCs and these are the STs who are present. Who has the power to add name into it? Who has the power to add a caste, remove a caste from this? Basically, Parliament will pass a law, and through this law, some castes would be added, some castes would be deleted from this central list, and then the president shall notify this order in the SC/ST order of 1951. What are we discussing? There is a central list. There is no state list of SCs and STs. That means all those SCs who are mentioned in the central list, all those STs who are mentioned in the central list, they get reservation throughout the country, in government jobs, in educational institutions. Who can add a caste into this group? Who can remove a caste from this list? That will be done by the Parliament. Parliament will pass a law, and then the president will notify this law. This is the procedure. Now, what has happened in Manipur? There are Métis. Some Métis are scheduled castes. Some Métis are other backward classes. But Métis were not STs. Métis were not STs. Some of these Métis petitioned the Manipur High Court. That we should also be included in the ST list. And what High Court did? High Court issued an order and asked the central government that you should, as soon as possible, add Métis into the central list of STs. Because once they are added to the central list of STs, throughout the country, they get reservation in government jobs and in educational institutions. The Manipur state, other tribals, such as Kukis, such as Zos, such as Nagas, they protested. Ultimately, there was a clash, and we are witnessing the clash right now where Manipur is under chaos. But this order of the High Court of Manipur is wrong. Why? Because the Supreme Court has said previously that no other entity, no state government, no judiciary, no high court can issue a directive to the center to add a name to this list, to remove a name from this list. This can be done only by the parliament by enacting a law and then president notifying this SC/ST order which was issued in 1951. It is only through this presidential order that names can be added, deleted from this list. That means if Métis were to be added to this ST list, this order should have been done by the President of India based on the law passed by the parliament. It cannot be done on the orders of the judiciary. It cannot be done on the orders of the state government. That's what the Supreme Court has said. But the point is, when it comes to other backward classes, or the term that is used for them is SEBCs. And what is SEBC? Socially and educationally backward classes. This OBC, it has a central list. It has a state list as well. That means for SCs and STs, there is central list only. Only these are SCs, only these are STs. But for OBCs, for socially and educationally backward class of citizens, central list is separate, state list is separate. It may be possible that there are some communities which are in the OBC list of a state, but they are not in the OBC list of the center. That means they will get reservation in that state, but they will not get reservation at the central level. So states have their own list of socially and educationally backward classes of citizens. Center has its own list. But when this 102nd Constitutional Amendment Act was passed, it was challenged before the Supreme Court, and Supreme Court said, no. States cannot have their own list. Because once you have given it a constitutional status, we are looking at this National Commission for Backward Classes in the same manner as we look at National Commission for SCs, National Commission for STs. If STs have one common central list, SCs have one common central list, that means for OBCs also, there will only be one common central list. That means only the president can add a name to this OBC list. Only a president can delete the name from this OBC list. States protested. States said that means you are depriving the states of their right, of their power to have their own list of socially and educationally backward classes of citizens. Even the government told the Supreme Court that this is not our intention. It's not the intention of the parliament that we should have now one common OBC list. No, states can have their own list as well. The court said no. Now there will be a common SC list, common ST list, common OBC list. To nullify this judgment, Constitution was amended again. 105th Constitutional Amendment Act was passed, which came into force from the 15th of August 2021. It is this constitutional amendment which restored the power to the state government. That now state governments, you can also have your own list of socially and educationally backward class of citizens. Because previously, Supreme Court tried to snatch this power from you. Long story short, 102nd Constitutional Amendment Act talked about and gave constitutional status to National Commission for Backward Classes. But previously, we used to have a state list of OBCs, central list of OBCs, which means state list of socially and educationally backward class of citizens and central list of SEBCs. The court said no. Just like SCs and STs, we have one common list. For OBCs also, we will have one common list. That's why you gave it a constitutional status, to make it at par with SCs and STs. So now states will not have the power to have their own list. Who can add a name to this OBC list? Center. Who has the power to delete a name from this list? Center, which means the President of India. That means the states were deprived of their right, of their power to have their own list of OBCs or socially and educationally backward class of citizens. Constitution was amended again. 105th Constitutional Amendment Act was passed, which restored the powers of the states. That now the states, you can have your own list of OBCs. That means now we have a central list of central list of SCs, central list of STs alone. But for SEBCs, we have the central list, we have the state list. And all the states, as well as union territories, they have the right to add or delete names from this socially and educationally backward class of citizens. Clear? That completes our discussion on fundamental rights. And finally, this chapter, fundamental rights, is over. Members of this commission has to be from the same community. So SCs are eligible to become the chairperson, vice chairperson, and members of NCSC. STs are qualified to be appointed as chairperson, members of National Commission for Scheduled Tribes. Okay. Directive Principles of State Policy under Part 4 of the Constitution. What do we mean by directive principle of state policy? Just look at this phrase. What are the principles that direct the state when the state is making policies or when the state is enacting laws? Those are what we call directive principles of state policy. Whenever I teach, I have something in mind that I assume you're all beginners, you have no idea about polity. I will start from scratch and gradually build on it. Similarly, when the state is enacting laws or when the state is enacting policies, what are the principles that the state will have to keep in mind while doing this? Those principles are what we call directive principles of state policy. We discussed Articles 12 to 35. They come under Part 3 of the Constitution. Article 36 to 51 come under Part 4 of the Constitution, which is Directive Principle of State Policy. What is Article 36? Definition of state, which is equal to the definition of state under Article 12. The term state that you find mentioned in Part 3 of the Constitution. Who is that state against whom you can claim your fundamental rights? That is provided under Article 12. In directive principle of state policy also, we encountered this term state. The state has to do this, the state has to do that, the state has to do this. Who is the state which has to keep these principles in mind? The definition of the state is mentioned under Article 36 of the Constitution. And the definition is same as that of Article 12. So whatever is the state under Article 12, that's the state under Part 4 of the Constitution as well. No difference. And all other directive principles, beginning with Article 37 to 51, these are positive obligations of the state. And we have borrowed these provisions from the Constitution of Ireland, the Irish Constitution. What are these positive obligations? I told you when we started the chapter on fundamental rights. I told you that fundamental rights are basically negative obligations on the state, limitations on the state, restrictions on the state. That state, you cannot interfere with the life and liberty of an individual. State, you cannot discriminate. State, you cannot deny equality before law. State, you cannot deprive an individual of his right to life and personal liberty except according to the procedure established by law. State, you can't do this. State, you can't do that. So fundamental rights are basically restrictions, limitations on the powers of the state. But directive principles are positive obligations. We are asking the state, please interfere. Please interfere so that we can have uniform civil code in India. Please interfere so that we can establish panchayats in India. Please interfere so that we can have equal pay for equal work in India. Please interfere so that we can enhance the standard of living of the people of this country. Please interfere so that we can establish welfare state, a welfare state which exists for everybody, a welfare state where the state interferes so that in society, in social relationship, in economic relationship, there is upliftment of the people. And that is why I told you that fundamental rights are for the promotion of political democracy, and directive principles are for the promotion of social and economic democracy. That means socially and economically, the state is there to ensure welfare of everybody. And all these denote the ideals that the state has to keep in mind when the state is making laws, when the state is enacting policies. Those are what we call directive principles of state policy. But Article 37 of the Constitution talks about two important characteristics of DPSPs. Characteristic number one, they are not enforceable in a court of law. Are fundamental rights enforceable in a court of law? Yes. What does that mean? That means if your fundamental rights are violated, you can approach the court. The court will issue writs, and through these writs, the courts will protect your fundamental rights, enforce your fundamental rights. That means fundamental rights are enforceable in a court of law, but directive principles are not enforceable in a court of law. Which means if the directive principle says uniform civil code should be implemented, if uniform civil code is not implemented, you can't go to the court. You can't go to the court and ask the court, please issue a mandamus to the parliament that parliament should enact a uniform civil code. You can't do that. Why? Because DPSPs are not enforceable in a court of law. Why are they not enforceable in a court of law? Park your question. We will get back to the answer to this question slightly later. And I will tell you later, once we are done with DPSPs, why DPSPs are not enforceable in a court of law. But I won't tell you now, I'll tell you later. Because right now I don't know the answer. I know the answer, but I'll tell you later. So characteristic number one, under Article 37, Constitution says directive principles are not enforceable in a court of law. Why? I'll tell you later. And second important characteristic, nevertheless, these directive principles are fundamental for the governance of the country. Article 37 says, directive principles are not enforceable in a court of law. Characteristic number one. But characteristic number two, they are so important for the governance of the country that it shall be the duty of the state to implement them. Sir, isn't it contradictory? On one hand, we are saying that directive principles are fundamental for the governance of the country. It shall be the duty of the state to implement these DPSPs. But at the same time, we say they are not enforceable in a court of law. We will discuss this later. But here, directive principles of state policy. As the name suggests, these are those principles that the state has to keep in mind when the state is enacting laws, making policies. Those are what we call directive principles of state policy, which comes under Part 4. And in Part 4, we have Articles 36 to 51. Article 36 talks about definition of the state. That means who is the state which has to implement these DPSPs mentioned under Article 36, which is same as Article 12. But Article 37 talks about two characteristics of DPSPs. They are not enforceable in a court of law, but at the same time, they are so important to be implemented. They are fundamental for the governance of the country that it shall be the duty of the state to implement them. Because the purpose of DPSP is to ensure social economic democracy, is to ensure a welfare state where the state exists for everybody, for the weak, for the poor, for the downtrodden, for the marginalized sections of the society. When we look at all these DPSPs one by one, right from Article 38 onwards, because Article 36 is the definition of the state. Article 37 talks about two important characteristics. The real DPSPs start with Article 38 till Article 51. When we look at all these directive principles from Article 38 to 51, we can see that some of these DPSPs are socialist in nature. Some of these DPSPs reflect the ideology of Mahatma Gandhi. Some of these DPSPs are liberal intellectual principles. And sometimes this question is asked in your prelims examination. Which of the following DPSPs are Gandhian in character? Which of the following DPSPs are liberal intellectual in character? Which of the following DPSPs are socialist in character? Does that mean you have to remember and memorize all these DPSPs so that you are able to answer the question in the examination? No. Why? Because even if you have not read any of these DPSPs, even without reading any of these DPSPs, you should be in a position to make out whether this is a Gandhian, this is a liberal intellectual, this is a socialist principle. And this is an assignment for you today. Once the class is over, go through M. Lakshmikant, take a look at all these DPSPs, and then see whether you can identify whether this DPSP is Gandhian, socialist, or liberal intellectual. And you will be able to answer that if you understand the difference between the Gandhian, the socialist, and liberal intellectual principle. For example, if I were to ask you, the state shall ensure equal pay for equal work, what sort of directive principle would it be? Gandhian, socialist, or liberal intellectual? Socialist. Why? Because this reflects the ideology of socialism, which we have discussed in the preamble. If the DPSP talks about that we need to enhance the standard of living of the people, what sort of directive principle would it be? Socialist. If the directive principle talks about that the state shall ensure that workers of the factories are involved in the management of the factories, what sort of directive principle would it be? Socialist. If a directive principle says the state should ensure that there is no concentration of wealth in fewer hands, only some are rich, the remaining are poorer, what sort of directive principle would this be? Socialist. Because socialism talks about distribution of wealth. If there is a directive principle which talks about ban on intoxicating drinks such as liquor, what sort of directive principle would it be? Gandhian, because Mahatma Gandhi was in favor of prohibition. If there is a directive principle which talks about establishment of panchayats in every village, what sort of directive principle would it be? Gandhian, because Mahatma Gandhi believed India lives in the villages. If there is a directive principle which talks about that the state has to keep in mind, the state has to take steps to uplift SCs and STs. Mahatma Gandhi talked about Harijan Seva. Mahatma Gandhi talked about penance. Mahatma Gandhi, even though there was a bomb attack on him, but that did not deter him. He said these Dalits, these are basically Harijans, children of God, and we have subjugated them for centuries. We have to apologize to them. We have to do Harijan Seva. So for SCs and STs, if there are schemes to be implemented, that directive principle is a Gandhian directive principle. But when we discussed preamble, I also told you that what is a stateless state? What is this communist state for Karl Marx? That is Ram Rajya for Mahatma Gandhi. So there is a marriage of ideas between Mahatma Gandhi and Karl Marx. That is why some directive principles, when you will read, you will find out that these DPSPs reflect the blend of both. These are Gandhian as well as socialist. And that is how Article 43, for example, is Gandhian as well as socialist. Article 47, for example, is Gandhian as well as socialist, because there is a commonality, some similarity between the idea of Mahatma Gandhi and Karl Marx. But if there is a principle, directive principle, which says there should be separation between executive and judiciary. It's a liberal intellectual principle. If there is a principle, directive principle, which says that the state can resolve all problems through talks, through peace, through negotiation, it's a liberal intellectual principle. If there is a directive principle which talks about monuments, places of heritage are to be protected, environment is to be protected, the state should protect environment, natural environment, forests, wildlife, it's a liberal intellectual principle. That means all these DPSPs between Articles 38 to 51, although Constitution has not divided them into Gandhian, socialist or liberal intellectual principles, listen to me carefully. This is not the classification done by the Constitution. Constitution does not say that we are dividing DPSPs into liberal, into socialist, into Gandhian principles. No, it's the constitutional experts who, by looking at the Constitution, interpreting the Constitution, they think that it seems that some of these DPSPs reflect the idea of Mahatma Gandhi, some reflect Gandhian principles, some reflect socialist principles, some reflect liberal intellectual principles. Constitution has not divided and classified these DPSPs. But the assignment for you, take a look at all these DPSPs. Once you read them, even if you're reading them for the first time, you should be able to make out whether it's Gandhian, liberal intellectual, or socialist principles. But on some, you may be confused that some represent the ideology of Mahatma Gandhi as well as socialism. And some reflect liberal intellectual as well as Gandhian principle. How? Animal husbandry should be carried out on scientific lines. Liberal intellectual principle. And then there should be a ban on cow slaughter and other milch animals. Gandhian principle. Clear? Done? But then there are some directives which are not mentioned under Part 4 of the Constitution, mentioned outside of the Part 4. Just like rights. There are some constitutional rights, for example, fundamental rights. Are fundamental rights constitutional rights? Yes, mentioned under Part 3 of the Constitution. But there are other constitutional rights other than those mentioned under Part 3. For example, the right to vote. For example, the right to property. Similarly, there are directive principles which are mentioned under Part 4 of the Constitution. But then there are some directives. What are directives? Basically, what are the principles that the state has to keep in mind while making laws, while enacting policies? There are some directives which are outside of the Part 4 of the Constitution. Which are these directives? For example, Article 335. Where have we discussed Article 335? Can anybody tell me? Reservation. What did we discuss in reservation? That OBC reservation is constitutional provided you meet 5 constitutional requirements. One such constitutional requirement is Article 335. That means reservation is constitutional subject to Article 335. And what is this Article 335? It's a directive. Directive to the state. That state, come here. What? There will be claims by the members of SC and ST community. They will claim. Where they will claim? They will claim government jobs, appointments to various services and posts, whether at the union level or at the state level. State, come here. There will be claims by SCs and STs in government jobs. You should take into confidence, into consideration those claims, but without flirting with the merit, without sacrificing efficiency in administration. That's a directive to the state, but not under Part 4, but outside of the Part 4 under Article 335 of the Constitution. There is another directive. Under Article 350, capital A, Maharashtrians in Tamil Nadu. Who are these Maharashtrians in Tamil Nadu? Linguistic minorities. For the children of these linguistic minorities, Tamil Nadu government has to ensure that children belonging to these linguistic minorities, they should be taught in their own mother tongue, which is Marathi, at least till the primary stage of their education. That's a directive. Under part, not under part 4, but under Article 350 capital A. There is a directive to the state. State, come here. Who is the state? Let's say the state of Bihar. There will be Tamils in your state. Who are these Tamils? Linguistic minorities. There is a directive to you that you have to ensure that their kids are taught in their own mother tongue at least till the primary stage of their education. That is a directive under Article 350 capital A. Sir, but then what is the difference? Directive under Part 4, directive under 350 capital A. Directives under Part 4 are not enforceable in a court of law. That means if the state wants, it can implement. If the state does not want, it may not implement. Because discretion is given to the state. But mind you, if the Bihar government, for the Tamil linguistic minorities, if they are present in Bihar, if they are not taught in Tamil till the 5th stage, till the primary stage of their education, a directive can be sent by the central government. Central government will tell Bihar government, it is your duty, do that. If you don't do that, we will ensure that your government is dismissed. President's rule can be imposed in your state under Article 356 of the Constitution. That is the power under Article 350 capital A. This directive, if it is violated by the state, that state can be dismissed by the center. Similarly, 351. Sir, this government, central government, is blatantly promoting Hindi at the expense of the beautiful South Indian languages. Tamil, Kannada, Telugu, Malayalam, Odia, these languages are being relegated, discriminated against. And the government is blatantly promoting Hindi. And now Mr. Amit Shah is saying that Hindi should be the national language, although Hindi is not a national language. All India radio bulletins in Hindi. Prime Minister speaking at the United Nations in Hindi. And every time Hindi, Hindi, Hindi. Mitron, what is Hindi? This is unconstitutional. But it is not. Why? Because there is a directive to the center. There is a directive to the union, which is the central government, that it shall be your duty to promote the spread of the Hindi language so that Hindi language can become a medium of instruction for all the elements of the composite culture of India. You have to promote Hindi. That is your duty under Article 351. Which means what is a directive? A directive to the state. What you have to keep in mind. A message to the state. What you have to keep in mind when you are making laws, when you are enacting policies. Some directives are under Part 4, which are not enforceable in a court of law. But some are outside of the Part 4. For example, 335. For example, 350 capital A. For example, 351. Clear? Something else. Article 37. Directive principles are not enforceable in a court of law. Nevertheless, it shall be the duty of the state to implement these directive principles of state policy. Because these DPSPs are fundamental for the governance of the country. What if the state wants to implement these directive principles? But then what if, by implementing these directive principles, fundamental rights under Part 3 of the Constitution are violated? What will prevail? Directive principles or fundamental rights? That's the key question. And this question arose. Madras government, 1951, issued an order. And now this time I can be more specific. To implement Article 46 of the Constitution, which is directive principle of state policy. What is Article 46? A directive to the state that you have to take steps for the upliftment of SCs and STs, for the upliftment of these backward classes. You have to take steps. And what Madras government is doing? Implementing Article 46. By taking a step for the upliftment of SC and ST community. And what is that step? Reservation. Reservation in government jobs, reservation in government educational institutions, government engineering and medical colleges. We are taking a step for the upliftment of SC and ST community under Article 46 of the Constitution by providing reservation to them in government engineering and medical colleges. Matter went to the court. Champak Dorai Rajan versus State of Madras, 1951. Supreme Court said this Madras government order is unconstitutional. Why unconstitutional? Because it violates Article 15 of the Constitution, which is a fundamental right. And fundamental rights are superior. Directive principles of state policy are inferior. Who said this? Supreme Court, Champak Dore Rajan case. But sir, we want to implement DPSPs because Article 37 imposes a duty on the state that you have to implement DPSPs because it is your duty, because it is fundamental for the governance of the country. Court said, yes, you can do that. But implement DPSPs to ensure that you don't violate fundamental rights. Because fundamental rights are superior, DPSPs are inferior. Because if these DPSPs were superior, then they would have been enforceable in a court of law. Since they are not enforceable in a court of law, which means the Constitution has given an inferior status to DPSPs as against fundamental rights. Fundamental rights are superior because we can enforce fundamental rights. And then you know what happened. Parliament got together, amended the Constitution, added Article 15, Clause 4 to the Constitution, to Fundamental Rights chapter. But that is the separate point. The point here is, now the court has said the relationship between fundamental rights and DPSP is that of superiority and inferiority. Fundamental rights are superior, directive principles are inferior. But this judgment had an impact, had a massive impact. And what was the impact? The government, headed by Pandit Nehru, wanted to implement two DPSPs. Article 39 Clause B, Article 39 Clause C. These two directive principles are very important. You should memorize them. Article 39 Clause B said, the ownership and control of material resources are so distributed so as to subserve the common good. During the colonial period, there used to be zamindari system. Who are these zamindars? They don't work on these lands. They hire agricultural laborers. But they control thousands and thousands of acres of land. And whatever profit they generate, they just give peanuts to these agricultural laborers, but they profit the entire profit to themselves. The place was Karachi. The year was 1931. Sardar Patel was the president of the Indian National Congress. Some decisions were taken. Some decisions were taken later on as well. Decisions were that once we will attain independence, we will ensure that our people will have fundamental rights. And we will also ensure economic development of the people. It was the promise of the Congress party to the people of India that once we will attain independence, because right now British cannot do this, but once we attain independence, we will ensure that the zamindari system is abolished. And when this zamindari system is abolished, we will and we shall implement land reforms. What is a land? Land is a resource, a material resource. The state has to ensure that the ownership and control of this land should be distributed so that it leads to the maximum happiness of the maximum number of people, so that it subserves the common good for everybody. Land, which is a material resource, should be divided equally amongst the people. Article 39 Clause C, the operation of the economic system should not result in the concentration of wealth to a common detriment. That means there should be no concentration of wealth in fewer hands. Because of the zamindari system, there are only a few people who are rich. The bourgeois, the capitalist class, the zamindar. The entire money is concentrated in their hands. The poor get nothing. The common janta get nothing. The Aam Aadmi, where even this Kejriwal's party does not talk about Aam Aurat, but Aam Aadmi, patriarchy. But when this Aam Aadmi gets nothing, we have to implement these two directive principles of state policy. And for that, what we need to do, we need to abolish the zamindari system so that we implement Article 39 Clause C. We need to implement land reform so that we implement Article 39 Clause B. These two directive principles, 39B and 39C, were implemented. Zamindari was abolished. Land reforms were implemented. Pandit Nehru was the Prime Minister. Matter went to Patna High Court. Patna High Court said, how dare you? You have violated Article 14, 19 and 31. What is Article 14? Article 14 talks about equality before law. So these zamindar said, why should we be deprived of something and this should be given to some others? Why is state differentiating between citizens? Is that not violation of equality? Yes, it is. Article 19, 1F, which I told you we will discuss in DPSPs, which was a fundamental right. This fundamental right talked about acquisition and disposal of property, which was available to all the citizens. As a citizen, I have the right to acquire property. As a citizen, I have the right to dispose of property as well. But here, who is disposing your property? It's state. Is that not violation of Article 19? Yes, it is. And Article 31 of the Constitution. And what is Article 31 of the Constitution? Compulsory acquisition by state. The state can acquire the property of individuals. The state can acquire private property as well. And this is where we come across a doctrine known as the doctrine of eminent domain. If it is for the larger public good. Despite the fact that you have right to property under Article 19, Clause 1, Clause F, that does not mean that the state cannot acquire your property. The state can compulsorily acquire your property if it is for the larger public interest, if it is for the larger public good. Which means I can acquire your property because I have to lay down a railway track. I can acquire your property because I have to set up a hospital. I can acquire your property because I have to set up an educational institute. I can acquire your property if it is for the larger public good. But even then, Article 31 said compensation should be provided. Compensate me. You are depriving me of my property. Compensate me. But Pandit Nehru said, how can we compensate these zamindars? We don't have enough money for that. These zamindars control thousands and thousands of acres of land. How can we provide them compensation for that land? And Article 14 is violated, Article 19 is violated, Article 31 is violated. Patna High Court says this Land Reforms Act is unconstitutional. Because don't you dare give effective directive principles and thereby violate fundamental rights. Because fundamental rights are superior, directive principles are inferior. Pandit Nehru was sitting with his colleagues. What do we do with this? Pandit Nehru was told, let's amend the constitution. Okay, what do we do? We will add Article 31 capital A to the constitution. And we will add Article 31B to the constitution. Sir, what is the difference? Tell me quickly. I'm losing my patience. Sir, 31 capital A would say acquisition by the state of any estate shall not be deemed as violation of Article 14, 19 and 31. So we are basically abolishing zamindari system. We are basically taking over their estate. Although it is violation of Article 14, 19, 31, but we will say Constitution says when you abolish zamindari system, when you take over estate, it shall not be deemed as amendment to the Constitution. It shall not be deemed as violation of Article 14, 19, 31. This is wordplay. Yes, sir, it is. But that's how we can do it. Otherwise, we will never be able to implement Land Reforms Act if till the time we have right to property as a fundamental right. Is that right? And the state can take over the management of any property in public interest. Or if a property is not being managed well, if any company is not being able to manage well, we can take over the management of that property as well. That is something that we will do. And for that, when it is not violation of Article 31, which means we don't have to pay compensation either. So you're right. So what is 39B and 39C? Two important directive principles which were implemented to give shape to DPSPs. Zamindari was abolished, land reforms were implemented. Patna High Court said, no, you can't do that. Why? Because Article 14, 19, 31 is violated. What is the alternative? Amend the Constitution. Amend the Constitution by adding 31 capital A, saying when the state is acquiring an estate, it is not violation of Article 14, 19, 31. It shall not be deemed as violation. And we can take over the private property in public interest. If a company is not being managed well, we can take over the management of that company in public interest. And when it is not deemed as violation of Article 14, 19, 31, which means we don't have to even pay compensation. Pandit Nehru was happy. Very good, we will implement this. Somebody else told him, Pandit Nehru, come here. What if judiciary challenges this? What? What if judiciary says you can't do this? Judiciary can say this. So I have a suggestion. Add 31 capital B to the Constitution. What is this 31 capital B? Basically add 9th schedule to the Constitution. There are 8 schedules. You add a 9th schedule. Why? Because, sir, what is a schedule? An explanatory memorandum of an article. If an article requires more explanation, we add a schedule to the end of the constitution. Yes. So we will talk about 31 capital B, but the explanation would be mentioned in ninth schedule, which means any law which is placed in ninth schedule, there is no judicial review. Judiciary cannot question it. And in this ninth schedule, we will keep on adding those laws where we don't want judiciary's interference, where we don't want judicial review to take place. That is how the Zamindari Abolition Act, this Land Reforms Act, was placed under ninth schedule of the Constitution. Judiciary cannot question this. And ultimately, land reforms were implemented. 2 DPSPs were implemented. But even if DPSPs were implemented, question still remains the same. DPSPs are inferior, fundamental rights are superior. Perhaps all this story was told to Srimati Indira Gandhi by her father, Pandit Nehru. And that is when she became the prime minister, she wanted to do something else. What she wanted to do? First, she wanted bank nationalization. And she wanted to abolish the privy purses. What is this bank nationalization? What is this privy purse? How Indira Gandhi got the parliament to do this? What impact does it have on the relationship between directive principles and fundamental rights? That we will discuss tomorrow, 6 o'clock in the morning. Any questions as of now? Let me know. Then we will meet tomorrow. So, Keshavananda Bharti case. There we will discuss how, after Keshavananda Bharti case, there is still a review of the laws placed in ninth schedule. Same-sex marriages, that will be decided by the Supreme Court today. So there is a case, it's a Navtej Johar case in 2017. Supreme Court said right to love is also a fundamental right. So homosexuality is not a crime. Then the corollary should be, if homosexuality is not a crime, if same-sex relationship is not a crime, then same-sex marriage should also be allowed. But under the existing marriage laws that we have, whether it is under the personal laws, whether it is under the Special Marriage Act, one party should be male, the other should be female. That's the prerequisite to get married in India, which means same-sex relationship can continue, but same-sex marriage is not allowed. And that is how this matter was challenged before the court. But it's a very intricate question. It's a very delicate question. Why? Because if you allow same-sex marriage, then what about inheritance? What about adoption? What about divorce? Should the same-sex marriage be under personal laws or under the Special Marriage Act? Then you will have to enter the domain of the personal laws. In absence of the Uniform Civil Code, we can't enter into the personal laws. So there is a lot of ifs and buts that will happen. But my sense is the Supreme Court will allow same-sex marriage without interfering with the personal laws by saying the same-sex marriage should be conducted under the Special Marriage Act of 1954. And we will discuss tomorrow what is the Special Marriage Act, what are these personal laws. Follow that special majority, amend the constitution. All 5 are appointed by the president. Known as transformational constitution, and something known as non-retrogression of rights. That means once rights are given to you, then you should not snatch those rights. You can only enhance those rights. So if your right to love is provided, you can't now snatch it back saying you don't have the right to marry. You can enhance it by saying now you have the right to marry. To make polity look easy, you can be thankful to me by qualifying this exam. Note, I don't think there is any difference. Content remains the same. So the syllabus remains the same. Depends on what you like. And whichever class you like, make notes accordingly. He's a fantastic teacher. Nobody would teach you wrong. Maybe he has a different style, I have a different style. Content remains the same. Verdicts remain the same. Goodbye.